Once again, the communication process is broken down.
Boy, that escalated quickly.
You can't handle the truth.
What'd you say?
Here comes the judge. Here comes the judge.
What you are witnessing is real. The participants are not actors.
All rise and like, subscribe, and bang the gavel, baby.
Court now in session here on a beautiful April the 20th, 2022. So it's 4/20/2022. There you go. Got it out. Guys, we're going to be watching some Zoom court from across the nation jumping around. I tried to watch some of that Johnny Depp stuff. Oh my God. I wanted to fall asleep. He was so boring and droning on, but I defer. Hello, our guy. Everybody's here. We're going to jump right into this. Please take a second and like this video. We would appreciate that because it means the world to us. We're going to start here listening to Brittany. Don't know what Brittany's talking about. Don't know what this case is about. But we're going to go ahead and slide on in and see.
Is it a doctor, a nurse practitioner, or what?
No, he's a medical doctor. He's an MD.
Okay. And would you have any problem with he and if there's a psychiatrist involved communicating and making a joint decision as to what to recommend in terms of medication?
I would not have an issue with that. From my understanding, Mr. Bose is wanting to change Raymond's pediatrician, which I've also said is fine because it's closer to both of us. It's going to be in Centralia.
Did she call her baby daddy Mr.?
Where's the current pediatrician located?
In Puyallup.
Okay. All right.
Hello, Anne. Terminator.
And that's been his pediatrician since he was born. But
Nancy,
I would have no issue with a psychiatrist and a medical doctor as long as it's an actual MD making a joint decision.
Our guy.
I have no other questions. Mr. Bose, specific to what I just asked, do you have any questions to follow up?
No, Your Honor.
All right. Mr. Arnold?
No, Your Honor.
No, Your Honor.
All right. Thank you, Ms. Richardson. All right. So at this point, the court's going to call Mr. Arnold to testify.
Good morning, Your Honor.
Good morning. Do you
It's
swear or
terrible
affirm
to-
the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And for the record, your name, please?
Jeff Arnold, GEOFFARNOLD,
I've seen Jeff before.
and I'm the guardian ad litem in this matter.
And you are on the registry for the guardians ad litem for Grace Harbor County, is that right?
Jenny, I hope you have a good time.
When I was appointed, yes. Technically, not now.
And that's because you've asked to take a hiatus?
Correct.
Okay, you were not removed by the court.
Not to my knowledge, no.
Okay. And you've undergone all the training for a guardian ad litem and have testified in a number of prior cases in this court, is that correct?
Yes, I would say I've been in probably close to 200 cases at this point, Your Honor.
All right. So I'm going to let you testify in a minute with regard to
Oh, the judge got the world's worst internet.
Anything that may be new or of concern to you at this point. So go ahead, Mr. Arnold.
Your Honor, the court is aware this is a long-standing case, and I agree that a resolution will benefit everyone. I think the issue is stability. If you want to have a overarching term, I think that is it in this case. As the court has heard, there's been issues with where the parties have resided.
I think they're trying to
there have been issues
figure out
primarily with Miss Richardson about who
something
she has
with a
resided
child.
with.
I don't know if I'm going to stick with this very long.
There's been issues with the financial abilities
Fred
of
Franklin.
the parties to contribute. although they both have. There has not been an actual any issue that I'm aware of where the parties have not been able to provide stable housing, food, clothing, things of that nature. But their situations have been precarious in terms to finances, to my knowledge. So I just think the end all be all is stability. And it's unfortunate
that Johnny Depp stuff
that
is
we're
just
in
like,
there, but that's where we're at.
oh my
I
God.
have met with Raymond once. He turned 5 in February, so young child. I did not get a lot of information from Raymond, as I didn't expect to. But I do want the court to know it's very clear.
Jay,
he
it
does
is
want to
very
see both
strange
parents,
already.
to me. I tried to ask him if there were any issues with the individual named Brian. He did not bring up any, but that doesn't mean there wasn't. I just want the court to know that he did not bring up any when I discussed that matter with him. And Miss Richardson is correct. He has a very limited history to what I can ascertain is solely consisting of traffic tickets. So he does not have any history regarding.
All right, we're jumping out of this. This
criminal
guy's
behavior.
put me to
So
sleep.
this court
He's bad as
granted
Johnny Depp.
probation because I do believe that he is a danger. And I think he needs help. And I hope that he is given the chance to seek help in a therapeutic community. But I think he would do well with some sobriety and TDC.
Thank you. All right, Mr. Santos, you know, I know it is hard to hear your daughter, and I'm sad for your daughter that you find yourself in this position. And, you know, I counted 8 DWIs. Was I wrong about that?
Whoa!
Was there 6 or 8?
8 DWIs.
Does anybody know?
I'll recount this, Judge. I am not looking at out of county. I'm not sure if there were.
Maybe I missed something in the PSI, but
I see. So there's 2 DWLIs in there.
oh, maybe that's what I counted by accident. All right, doesn't matter. 6 or 8 is way too many. The levels are way too many. Glad to hear you didn't drink around your family. Unfortunately, you were drinking around other people's families. And I seriously cannot take the chance of you hurting someone in this community and destroying somebody else's life. So I am denying your applications for community supervision in this cases. I will, however, follow your plea bargains in this case. And in addition to that, I will recommend you for the therapeutic community, and that's ultimately up to the prison system. So I'm finding you guilty in both causes, assessing a $1,500 fine in each, plus the court costs, sentencing you to the 8 years in TDC on these cases. They will run concurrent with each other, and the state is still going to take into consideration cause 2021 CR 9857.
I'm guessing TDC
You
is
will
Texas
receive all
Department of
credit for time
Corrections.
served. I will, as I said, recommend that therapeutic community. And I wish you lots of luck. And
I went over to Judge
hopefully you will
Cedrickson. He was like in the
maintain
dark
and
over there.
find what you need in terms of your recovery and sobriety. Good luck.
Did they just cut this? Oh, are you kidding me? Of course, of course. All right, well, we're jumping off out of this one onto another one. Unbelievable. The total disrespect for me. I don't have 8 DUIs.
$1,600 loan, but it wasn't dropping. It was even actually higher. And I was like, what's going on? This
I
does
saw
not make
some of
sense.
it, Kelly.
So I've called
It
you.
was very dark.
And again,
that
nobody at the
chase.
front could help. Russ is always busy because he's the
Did I,
only
Billy?
one that can help all the
Oh.
customers. So finally, Russ got a hold of me, and the only way he could explain to me is if I come into
This
the
is a
office.
small
And I said,
claims
"This
court, by the
doesn't
way.
make sense. Why can't you explain to me what is going on with my loan? You have to come in person. The only way I can explain it to you, it's very confusing. So come in person, and I promise you'll be happy. Blah 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 blah." So I did come in person. Sat down with Russ.
It is
And at
baby's
first,
time.
Russ was telling me that this was interest that has grown. That's why the loan is about $2,300. I was like, well, that just doesn't make sense because I've paid $850 worth of payments. I'm not a mathematician, but the number should be dropping. So he stepped away, came back with a piece of paper that shows that how he took off all the optional. Oh, sorry, I'm gonna backtrack a little bit because when I did take out a loan, I was supposed to put down a collateral. One of the collaterals is they always ask for a car title. I've mentioned that I don't have a car. I still don't have a car till this day. I don't need a car. So he's
Do a
like,
lot of
well,
walking,
can you
do
put
you?
anything down? How about a TV? So we wrote in a TV. So the Liberty Motor Club would make no sense for me to sign for because it absolutely makes no sense. If you don't have a car, Liberty Motor Club is something you don't need. So going back to what I
Who was
was
that?
saying,
Whose voice was that?
he came back with a piece of paper, which is one of the exhibits where it says the $540, just a second.
Who's trying to talk? Ed?
The
There's
total
an Ed
refund of
there?
$540, that's where he count, and all of these notes are written by Russ. They are
Yes,
not
I
written
saw
by me,
those.
and Russ is again. the
Several of
branch
those we've
manager over there.
done
So I
already,
consider
but
that this is a
we will
written
rewatch
agreement.
them at some point.
So he came back, the 540 equals
was
all
wild.
the optionals,
Wow.
additional options, including
Maybe
the
somebody would
Liberty
be nice
Motor.
enough.
I don't
send
see
it
that
to me.
Liberty Motor was refunded. Insurances were, and they weren't refunded in full. They were partially refunded. So looking at that note, he said 540 as a refund, calculated all my payments,
like
blah,
'em
blah, blah,
wild.
and then came back to that number, which is 1703 on Exhibit 2. I was like, well, if the loan was $1,600 and I made $850 worth of payments, how come it's still higher? It should be at least $1,500 or so. It should be
She's over there
somewhat
doing monkey
less,
math as
but
hard as she
not
can.
higher. So then he said, hold on a second, and stepped away again, and then came back with
Larry
Exhibit
Cobb,
3,
everybody.
where he wrote out all these numbers. He said, if I make a payment today of $270, which it states on Exhibit 3, that and then the final thing, it says, as of today, the balance is $773. So speaking to Russ, he's like, okay, so Anna, you're making it really hard for me. We're not making any money, but you're a great customer. We really like you. Your husband has gotten loans here. You've gotten loans. I'm gonna make you happy. So your current balance is $773. Are you happy? I said, absolutely. And that's exactly what because I'm here to make my customers happy. So then the last thing I heard from Russ is, do not make a payment. I'm gonna submit this to corporate. Once I submit it to corporate, you'll get a new revised bill of the $773, and that's when you need to start making payments. And including in that $773, we already calculated the interest. So the interest
Chris,
was
what's
already
going
calculated
on?
for the lifetime of the loan.
The
That's it
woodworker
in a nutshell.
himself.
I see. Ms. Hawthorne, do you agree or disagree?
This is our
that you have
this is
not
our courtroom that
made
we
any
usually have
payments
harassment
on the
court in.
loan since February of 2020?
I agree.
Okay. And is there any reason or
Pamela.
explanation as to why you have not made any payments since February of 2020?
I am still waiting for that paperwork where it says that I owe them $773 that we agreed on.
Appreciate it.
And I have not received anything. Again, I work for the same company that I provided them. I have not moved. I have not changed my phone number. I have not received a single bill. I have not received any phone calls. So if they can't make the paperwork correct, I don't think I should be paying on something that's incorrect. So we need to make it right. And then of course, I agree that I owe the amount, but not the amount that they're asking.
I see. So let me
For all
make
you
sure that
guys
I
watching on
understand this. Your
Facebook, do us a favor and
testimony
share this out. We need to
is
get
that
court
you-
on Facebook.
your-
They're trying to keep us out.
Your opinion or
We need
your
to get it out there.
theory here basically is that you believe that what you owe them is $773.29.
Mm-hmm.
Correct.
And you're getting that from, you indicate that you made you're saying you made $850 in payments?
$850 prior to 228. Then on 228, I made another $270 of worth of payments. So total payments that
I
were
think
made
you're
in
right.
this account.
She could be screwed.
Sorry, 1 second. 850 plus 270, so whatever that is.
Sure.
Sorry, math, I'm not a math person.
Oh, she's not a math person. I am. Don't you worry, honey. I'm here to help you out.
1120.
Let my fingers do the walking. Oh, please stay safe in there. That's I mean, lights go out, bad things can happen.
So I understand that your testimony is that
Those
Russ
son
and
of a
Mr.
bitches.
Yee, that he reviewed the documents with you fast. Do you agree, though, that you did sign these initial loan paperwork that's in the court file?
They want me to pay back more
I have
money
to
than
agree
I
to
borrowed,
that.
sir.
That is my signature.
Okay.
And
And the form that I'm looking at, it does indicate that you were to receive a total of, basically that day, you received funds in the amount of $1,595.34. The annual percentage rate was going to be slightly more than 29%. Total payments would be $3,000 over the life of the loan. And it does also indicate that there were other costs that were associated with that for Liberty Motor Club, insurance, what have you, that Mr. Black is indicating were later refunded or were removed from the loan. Do you agree with all of, at least what the initial paperwork said, Ms. Hawthorne?
yes and no. So the initial paperwork of where you said the lifetime of a loan would be 3,000, that includes the Liberty Motor Club and all the insurances. That's
Right.
with everything.
Right. No, I understand that. But
Okay.
that's what it said
everything, baby.
initially, at least.
The whole ball of wax. The whole 9 yards. Finally caught up with her. Columbia House is here to collect.
Was there anything
They're not
else
playing
that you guys
around.
could tell me, Ms. Hawthorne?
Make it good, because you're about to lose.
I think that's it. It's just where I'm really honing in at is on those handwritten notes that were handwritten by the manager of the branch. And I consider that as an agreement because I have an original agreement with them. But when I go back in and talk to the manager of the branch and he writes down the numbers, he breaks it down, those are all his handwriting. And it clearly states the balance as of this date, it has all the writing. So it's not just gibberish. It's not just jotting notes down. So I believe that is a contract and that is my final balance.
Thank you.
I see. All right. Thank you, Ms. Hawthorne. I'm going to hear from Mr. Block. He is the plaintiff, so he does have the burden of proving this. So I'll give him an opportunity to reply to what you've said at this point. Mr. Block, is there anything more you want to?
Yes, Your Honor. The first thing I would point out is when she was talking about canceling the insurances later on, you'll see that the note about the cancellation is actually dated, and it's dated the same day as when she took out the loan. I will, Mr. Yee, he talks fast. There's no ifs, ands, or buts about it. And I've
He
actually
talked out both
gone
sides of his
downstairs
face.
and seen him closing loans, and I've seen people ask him to slow down, explain this. You know, if you just sign and don't ask for an explanation, then
Thank you, Michael.
you've accepted it. You know, scratch papers are not a contract. The contract is a contract that everybody wrote. As far as this new loan that you know, Ms. Hawthorne has made reference to, it is not unusual for people to come in and write a new loan. We just don't send out a new bill and say, here you go. We have to go through all the proper documentation, just like the documents that I've submitted as you know, exhibits. You know, scratch paper is not a loan.
This isn't a loan? I thought this was a loan.
Do you agree? One
this
question
isn't
I
a
have
loan.
for you, Mr. Block. So that
Yes, sir.
the handwritten or the scratch paper, whatever we want to call it, it sounds like you agree that that was written by Mr. Yee.
That is his handwriting. Yes.
Anne is in trouble,
What-
Angela.
What is your
She's in trouble.
belief or your understanding as to
Geez,
what
Stephen
these
O'Neill.
figures mean? So, instance,
Great
there
White
is
North.
the $773.29 written in there.
Mhm.
What does that mean to you, if anything?
Well, honestly, I think this is when I go into my computer and look, there's absolutely no notes whatsoever regarding this. So is, you know, to me, it appears to be a what if we did this, what if we did that? Because there's absolutely no notes saying, there's nothing in the notes saying that, you know, we
Good
came up with a
morning,
new
Mavis.
deal of any type.
Good morning.
So I truly believe this is nothing more than a what if we do this, what if we do that type scenario.
A lot of hypotheticals. He was asking her what would happen.
And so I'm looking
She
over
met him
your
for dinner
account
one night.
statement. Does that support or deny Ms. Hawthorne's claim that she paid I think she's saying that she paid $270 on the same date where she canceled the insurance? Maybe I've misunderstood that though.
I don't know anything, and I don't know what she was talking about saying.
What
that
kind of
she made a payment
financial
on the
place
same
is
day.
this?
I have nothing showing
Some
that.
fly by night joint.
I did not see that, unless I was missing that. I did not see that in your account statement either. Ms. Hawthorne, I just want to make
Washed
sure
up.
that I understand. I'm gonna reopen with you for a second. Your testimony is, I believe, that you made an additional $279
Can I make payments on that?
on July 19th or June 19th of 2019.
No, I'm talking about February 28th, 2020.
Oh, so, okay. So the 270 was paid then.
Correct.
Okay. So this scratch paper that we've been talking about with the various numbers and calculations, when did Mr. Yee write that? Was it in June or was it in February?
February.
February. Okay.
Correct. So that's when I made $850 worth of payments and it wasn't making sense. That's when I was like, you need to explain this to me. And then I came into the office on February 28th, and that's when we went with all these papers trying to figure out where the discrepancy is.
Okay.
They're talking about
So I do
insurances and things like
see
that on it. I
on
don't
the
know. I'm
documents
guessing
that
it.
Mr. Block
They
provided,
were
and
talking
it
about a
seems to
car,
be
but then she said
uncontested
she
that there
doesn't
was
have a car.
$270 payment that was credited to you on that date.
But they did allow her to use a TV set
Mr.
as
Block, was there anything
collateral.
else you wanted to present?
No, Your Honor.
There has to be some shady shit going on in this place.
So I have considered all of the information that both of you presented today, as well as the exhibits that both parties presented. So the court will deem those admitted for the purposes of the small claims trial. Ms. Hawthorne, I am going to find in favor of Mr. Block.
Oh.
The reason that I'm doing that is that the written loan agreement, the contract that you reached with United Finance, does have some specific terms, and it does lay out specific interest rates, other costs, and terms that you did agree to, but in writing when you did sign with those. I do understand that your testimony is that you later had a different agreement
Nate the Great. Good
with
to see you,
Mr.
bud.
Yee based on the handwritten or the scratch paper documents. I think both of you have referred to those. I think we all know what we're talking about. They've been referred to as either the handwritten documents or the scratch paper. So I understand
This
your
loan was
position
made from
is that
scratch.
That basically is a new contract or a new agreement of some sort. However, I don't find that to be a convincing position for a few different reasons. One of which is it appears to me from your own testimony that you're familiar with United Finance and that you have done business with them on prior occasions.
You knew they were shady.
Also, I don't think it's reasonable or plausible to think that these documents, in the state of which they're in, which is basically handwritten calculations
scratch.
that are not signed by anyone and that don't have any of the indications that I think a reasonable person doing business for a loan would consider to be controlling or significant. I think Mr. Block's testimony that these basically are calculations as to something that could happen in the future, that seems to me more plausible than an argument that this somehow was a new binding agreement between you and United Finance. I just don't think that's particularly plausible. You yourself may have believed that, and I could see perhaps why you would, given what seems to be your dissatisfaction with the loan. But there's a difference between what you might believe and what the court has to consider as actually be reasonable or controlling. So I am going to enter judgment in favor of United Finance.
Surprise,
That
surprise.
will be for a total principal amount of $2,202.68. That's going to include the unpaid principal amount, as well as interest that accrued essentially from when you stop paying the loan, which you do agree you stopped making payments in February of 2020, as well as late charges that were agreed under the original contract that I'm finding to be controlling. We'll also assign a filing fee in favor of United Finance of $50. Were you requesting a service fee, Mr. Block?
Yes, Your Honor. The service fee was $50 on this one.
We have $50 service fee assessed as well. Ms. Hawthorne, the total judgment that will be entered against you in favor of the plaintiff will be $2,302.68.
Ouch.
Interest will accrue on that judgment at the amount of 9% per year. That amount is set by statute. So I have entered judgment in their favor.
We all been there, Flusha.
You do have the right to appeal that. If you wish to appeal that, you will need to contact Clark County District Court Administration within 30 days of today's hearing and file a notice of appeal. You will also have to post a bond that's required by statute. If you have questions about that, you can contact Clark County District Court. However, if you do not take the steps necessary to basically complete your appeal, including posting of the bond within 30 days, then you will not have the ability to further contest this matter. So that's the court's decision today. You will both receive a copy of the small claims judgment. Looks like you had a question, Ms. Hawthorne. What was that?
I do. The only thing is in all of it, so I was charged $542 worth of the additional charges that I was supposed to be refunded. I was only refunded in $263.69, not $542.
Uh-oh.
So the Liberty Motor Club was not refunded, and the insurance was not refunded what I was charged.
I understand that is your position, Ms. Hawthorne. I'm not agreeing with your position, though, so I'm finding otherwise, and I am finding in favor of United Finance based on the documentation before me. So that's the court's finding. If you do wish to appeal it, you have the right to do so. However, you will need to take the steps that I've already outlined. That's going to conclude today's hearing. You are both free to disconnect from this Zoom session.
All right. Thank you, Your Honor.
All right. We're going to jump. I'm going to use this as a quick buffer right here. Let's go here. And yeah, we're going to jump to another packed courtroom. The 175th district, Judge Torres. I think we've been here before. She looks familiar. I'll say that much. Make sure you guys are liking this video. Appreciate all the support. And let's slip right on in here and sit down without even being noticed. Shh. Use your inside voices, people. Are you kidding me? Is it going away right now? Are you? Ooh, sorry about that. I didn't mean to get upset, but that made me mad. Well, then we're going to an old friend's house. Take off your shoes, relax, as we saddle up to Judge Herman. Everybody's favorite jive court is now in session. The judge is here, so we're going to slide in here for a few minutes and try not to get sucked into the whole thing, because we tend to get sucked in from time to time. So let's go. No, that's me. Hey, me. That's Mikey. Mikey, everybody. The judge calling somebody? Oh, we're making a phone call. Just got here.
There's not even a voicemail picking up, Judge.
Okay.
Oh, that was it.
It's blank. No name stated.
No number.
Okay.
Your Honor, why don't we set it
Well-
for a formal trial on 5-4? That way I'll make sure that my witness isn't double booked.
Who is this guy, James?
I'll adjourn it to.
Is he an attorney? What's going on?
10 a.m.
Very good. Thank you, Your Honor.
You hear Iowa golfer. She said boycott American Financial.
Okay.
Yeah. If you got bad credit, you're going to keep having bad credit. It's tough to come back from. Well, I'm glad you came back, Christy. It's good. Good idea. Oh,
Here we
boy,
go.
Corey.
Ridgecrest Village Apartments versus
Come on, say James Borden.
Maya Porter.
Ah.
C21 G6443LT.
He is out to lunch right now. He had some
The record
heavy
Jeremy
stuff to
appeals in
handle
front of
this
the court,
morning.
Matthew Palace on behalf of the plaintiff.
No one by this name.
Damn right.
Who's that? Who's that?
Uh-oh, somebody's phone's ringing.
No, it's in here.
I don't know.
I hope it's his phone. God, I
Mr.
hope it's his
Fairley?
phone.
Is that your phone making noise?
That's right, baby. I'm here and
Mr.
I'm
Maya
ready to...
Porter here.
No one by that name is checked in, Judge.
Okay, so
Yes, it
again, this is one where I was told in January, actually, I was told in December that Sarah had been applied for. So what's
Yes, Your
going
Honor.
on?
Yes, Sarah has paid. I would like the court's indulgence to issue since the tenant's not here, I would have done it as a consent order dismissal. But we can reflect the payment amount received, and then
He switches
an order
it
of
up.
dismissal would be in the amount of $14.89, which is reflective of the shortfall plus April rent plus court costs. I'll put in the same language whereby she would be entitled to pay that within 30 days of the entry of the order, and then reinstatement on behalf of a hearing, if the court is so willing.
Angie,
Yeah, I
good
can
to
take a
see
look
you.
at
Okay,
That's
Glad
fine.
you're here.
okay, then that's what we'll present that to the court.
Bob, you should be sorry you're here. No, I'm just kidding. Glad you're here. James creeping on us, isn't he? He's like, what's going on here? I do like his decorated
Hang on.
walls like he's a teenage girl.
Give me 2 minutes.
Oh, Judge. Damn it.
Taking 2 minutes here. 3 minutes. 3 minutes.
It'd have been hilarious if that had been his phone ringing, by the way, huh? Well, while we're waiting for the judge to come back, we'll jump over here and we'll check out what's happening with our good friend, the judge.
Put your virtual hand emoji. If you're a dinosaur, you don't know what button to press or what key to press, just kind of wave at us and we'll recognize you, all right? So I've got Fabian Guerrero waving and putting his emoji. So you must have a flight to Las Vegas waiting for him.
I wish, Judge. Good morning.
Case number 2 is C334-22-J, Luis.
I saw something. I don't know what it was.
CJE
Lunchbox,
Construction
maybe?
LLC.
So, Judge, I do have a brief announcement, but it's not.
Okay,
on that
okay,
case.
tell me your name and who you represent, so Ms. Ariano can have an accurate record.
Fabian Guerrero on C0334-22J. I represent Luis Alberto Tijerina Ibarra, the petitioner in the case, but my brief announcement is not relating to that case, Judge.
He's only
It's
at lunch. He'll
relating
be
to
here
another case
for Wild
where,
Woman
I
Wednesday. No
represent
worries.
Jose Silva.
Okay, well, since I called that case and Mr. Flores, you
Okay,
represent
good
the
to see you.
defendant?
That's correct, Your Honor. We're the defendant and movement on a motion to compel arbitration and to abate this matter.
He's got
Okay, well, let me hear your argument. I mean, I've already called it on the record, so I'll take it out of order.
Judge is ready. Let's
Very
go.
well, Judge. And this is a case that was done. It's a residential construction contract case. I think it's imperative to note, Your Honor, that this contract that the party signed is a Texas Association of Builders contract. And this contract, as Your Honor may know, has been challenged multiple times and each time has been successful as far as its efforts to compel this arbitration process. Now, this contract that is part of the pleadings that we filed is a contract that's signed by all parties. Every page of that contract, Your Honor, and it is attached to my motion and is attached to my reply brief, shows that it's a
Maybe.
valid and binding contract signed by all parties, initialed on each page by all parties. Now, once we show that we have a valid and binding contract, we have to show here that the claims that are the basis of this suit fall under the provisions that should require us to follow and require the court to compel the arbitration. Now, what happened in this case, as detailed by their pleadings, is that there was an escalation of costs in the construction of the residence. The contract has an escalation clause, Your Honor, and pursuant to that escalation clause, we increased the price of the contract. At that point, the buyer refused to sign the change order, refused to agree to the escalation, and the contract was thereafter terminated. These are all terms of the contract that are applicable, and the basis of our claims are the terms of this contract.
I'm with you,
Again,
Nate.
this is the same contract that contains in it in section
My God, Johnny
17Q
Depp is boring.
of the contract, the arbitration clause. Now, if you take a look at this arbitration clause, Your Honor, it's an arbitration that's in bold print as required. Pages, I believe pages.
He's dropping the deuce.
17. And I highlighted this in my reply, Your Honor. Pages 14 of 20 through 16 of 20, the mediation and arbitration clause are in appropriate font, bolded. As part of this provision, mediation is mandatory. Now, the parties did already, pursuant to the terms of this contract and the arbitration clause, attend mediation, and mediation was unsuccessful. Thereafter, pursuant to the contract, the next step, of course, is to begin the arbitration process.
Oh my
We file a
gosh.
motion to compel
I'm about to have an
arbitration
arbitration in a second.
Now, the plaintiff did file a reply, Your Honor, to our motion to compel. And there's three arguments that the plaintiff.
Okay, let Mr. Guerrero make his arguments, because he can make a better argument on when he filed than you can make as to what he filed, okay?
Well, I did file a reply there too, Your Honor, and as part of my presentation, I want to explain to the court why the challenge
TK,
to
I
it,
have no idea
doesn't
what we're talking about
satisfy
over here.
or does not rebut. Remember, there is a strong presumption in favor of.
We're gonna go back over here and wait for the judge to return, because that guy makes me want to watch Johnny Depp. That's how bad he was boring me with that. Louise is taking us on a tour. James, of course, lurking as usual. Jessica still not on frame. Judge not back. It's been 2 minutes, has it not? I feel like Judge lied to us. He could have took us somewhere with him. I'm not saying the judge is being dishonest, but I think the judge is being dishonest. All right. Let's jump in over here. What the hell is with all these courtrooms ending as soon as I get in them? Apparently nobody wants me in court today. Mr. Legend, is it true you were watching court illegally? Yes, it is, Your Honor. All right, heading over to Judge Simpson, see what he's got going on. He's got quite a few people there. Judge Simpson.
Understanding, Mr. Williams, of what you'd like to do today.
Yes, sir. During the matter, May 18th, 2022, 9 a.m.
Oh, no, don't be adjourning a bunch of stuff.
For cause case, people versus D'Angelo Wood.
On behalf of the people.
Assistant Public Defender Brian J. Craig on behalf of Mr. D'Angelo Wood. Mr. Wood, if you're present on the call, please unmute yourself and state your name for the record, please.
Sounds that
D'Angelo
way.
Wood.
Thank you, Jeanette. Good to
You're
see
not
you.
here.
No, Your Honor. No contact with him by telephone either. No return calls.
Okay. Bench warrant will issue for defendant's failure to appear. 5,000, 10%.
That's what I was thinking, Ian. It was
we
very
have the
boring.
Previous warrant, so that's one we'll issue immediately.
Thank you, Your Honor.
Yeah. Court calls case of People versus Benjamin Woods.
Caitlin Kirby on behalf of the people.
Assistant Public Defender Brian J. Craig on behalf
It's
of Mr.
rough.
Benjamin Wendell Woods. Mr. Woods, will you please state your full name for the record, please?
You're muted. You can get
You're
yelled
not
at.
hooked.
I know he's at work, Your Honor. He's having some Wi-Fi issues. Mr. Woods, can you hear us?
Uh-huh.
Hear me?
Barely. Okay, we got you. Well, I can hear you. What's your name?
My name is Benjamin Wendell Woods Jr.
All right, we got you.
Benjamin Wendell
Thank you,
Woods.
Your Honor.
Jr.
Today is also date and time set for pretrial. He's in a similar position to Mr. Williams. He's asking for a short adjournment so he may continue with the sober link and work towards resolution in this case, also seeking outpatient treatment, dealing with this matter, working towards resolution with the prosecution.
May 18, 2022, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you.
All right.
You got James Farton over
Mr.
here.
Kirby, did you get Mr. Noakes stuff through, or should I recall that yet or no?
Not yet, Your Honor.
Okay.
By the way, our good friend Judge Herman said 2
Okay.
minutes and he still
Court does
hasn't yet
recall the
returned.
case People versus Kresnik.
Caitlin Kirby on behalf of the people.
James Gallagher, Assistant Public Defender on behalf of Michelle Kresnik. Ms. Kresnik, if you could please state your name again for the court.
Michelle Kresnik.
Hey, Michelle.
And Your Honor, thank you for the opportunity to meet with Ms. Kresnik. We could address the bond violation first, if that's okay with the court.
Yes.
Yes. Your Honor, I did go over that with Ms. Kresnik, and she was aware of it, Your Honor. She had already been in communication
Very
with
true.
Community Correction. She's taking it extremely seriously, Judge. I explained her options, and she wishes to admit to the violations, and then I could say some words on her behalf in regards to what the court may do.
Robert's intrigued down at the bottom.
All right. She admits to the violations. Go ahead. What do you want to say about this? Because that's a rather
Is she
high
about-
level.
She about to cry?
It is, Judge. Fully recognize that, and
crying.
as you can tell, Ms. Kresnik's taking this extremely seriously. She understands the court's concern here and the serious nature of it. What I would suggesting for the court to consider, as noted in the bond violation report, she's on a sober link. I'm asking the court to consider having her fitted with a scram tether.
I want to know what happened. She admits to the violation. I want to know why this happened.
Sure. Ms. Kresnik, you want to go ahead and address that with the judge?
Here we go.
Which portion?
All of it.
I want to know what happened. Why did I have a positive test?
It really sounds really stupid. I was at a barbecue and my son gave me a slush and I didn't know that there was anything in it. I know now, and I couldn't tell, probably because I've been so used to just drinking things. I don't have a good excuse, Your Honor. I don't have a good one. It's a poor one, and I told Mrs. Wild.
It's her
Ms.
son's
Wild,
fault. It was a roofie colada.
and I didn't. I don't have an excuse. I just don't have one. I don't have an excuse. It's completely my fault and my responsibility.
Oh, it certainly is. But I'm having a hard time believing
No
that
problem,
it was
Jen.
just one drink. One drink?
No. He gave me 2 slushes.
He gave
And
me
you
two.
couldn't tell after the first one?
She's like,
Sir,
damn, these are
You
good.
got
It's
to a point-
embarrassing
you
to
almost
say
got
that
to a
maybe I just don't
0.08.
even I'm sorry, sir. Pardon me.
You almost got to a 0.08.
I understand.
My son makes a very strong
And
drink,
I
Your
think
Honor.
that it's just because at this point, after
No.
so many years of just not even tasting it anymore.
No.
And Your
And
Honor,
You know what? She's gonna have to give me something better than that, because
Well,
I'm gonna tell you. I'm gonna tell you what, Mr. Gallagher. The problem I'm having is presumably since
Yeah.
at least the time that she's been
Giannis.
arraigned, since the beginning of this month, she hasn't had anything to drink. But the reality is I arraigned her on April 6th. She didn't make it 10 days
understood.
before we detect alcohol. And by the way, it's not like I have an 03 where somebody may have taken one drink. She's at an 08 effectively.
fully understand that, Judge. What I was going to suggest is if the court could order that she get involved with treatment, because I've been in communication with Ms. Kirby in regards to this, that may be advantageous to her in terms of possible resolution. No promises, of course, from the prosecutor, but
Before I'm gonna order anything other than jail, she's gotta tell me the truth about what was going on and what she was thinking, because I don't believe what she's telling me. That doesn't make any sense.
Nope. She's lying. She's full of shit.
So I'm gonna pass it and give her an opportunity. I've been doing this for a little bit,
I understand.
and what she's telling me, that doesn't make any sense.
The fruitcake was heavy with liquor.
So
She's
I'll
crying
pass
because
it
she
then,
got
and
caught.
We'll call it up at the beginning of our what's that, 2 o'clock?
2 o'clock?
Or 2 o'clock block, so she can think about what she wants to tell me. Because what she wants to tell me, or what she tells me, is really going to sort of meet out what I'm gonna do with it. Thank you, I'll pass.
Okay, thank you, Judge.
So effectively, he
Do I
just
what?
said, I want her to think about that lie she just told me. Because
From
that lie
officers,
she just
yeah.
told me is going to put her in
Yeah.
jail.
What
What a
case, the people
dumb
versus Demetrius? No. Well, are we ready on that one, or should I put that to the hour too?
Yeah, the 2 o'clock, Your Honor. I haven't gotten an email from him yet.
Okay, I'll put that. for
I
two.
just got in my car and I just found both of the papers. I'm finna email them now.
Okay, it's okay. It's okay, Mr.
Yeah.
Knopf. We were just trying to do that.
Nope, you're
I
fine.
didn't I thought your car might have been parked in Chicago, so we weren't gonna see.
Nope, I was trying to find the papers. I found them though.
Okay.
Good to see you, Street Green.
Okay, and there are warrants. What
Yeah.
kind of warrants? What are they trying to
Go
get
to-
me to do?
she's
I don't have any paperwork.
she's going to have to go to jail. That's the only thing that's going to help her right this minute. She had to go to jail. It's going to be a rough one.
Are the officers? Okay.
You think she's scrambling right now to make up another story, guys, or is she going to stick with it? I think she said 12 years old.
Oh, so the deputies have to come in.
And
So,
what kind
yeah,
of barbecue is it? Don't keep the kids
I'll
away
leave them, but
from
they have to be sent here
alcoholic
first, so-
slushy.
Court's gonna stand in recess, and then I'll come back on at our 2 o'clock time. Court's in recess.
Okay, we're going to stick with Judge. We're going to come back to him. But our other judge is back. Judge Herman is back and ready to
Judge
go.
Gordon Hamilton,
Yes, ma'am.
you're doing Judge Crawford's courtroom, courtroom
that's it.
2.
Next door.
It's not right next door. You have to go around the corner.
Oh, okay.
She's having her a drink right now, I bet. Wow, that's going to be interesting to see how that pans out.
Okay, what's next? This,
This one, no, that was,
what I just said.
yeah.
What I just said.
Wish that the attorney had sent me a message saying that she wanted to do this before I could have done it.
What is that on the screen at James's? Did you see that? You have like an ink pen? Is he trying to look?
Okay,
He's,
so
what
that's
are
the
we
same
doing?
attorney
They're
for the
writing
other
on the
two.
screen.
Then I guess we're gonna go back to this one.
Yeah, all that lying in front of the judge and all that crying and
If it pleases the court, David Bader's ready for National Check Bureau.
You don't, your case is in the afternoon, isn't it?
No, it was at 10:30 this morning.
This person was set at 9 o'clock though, that I'd like you to go back to, Judge.
I'm sure it
Is
happens.
Ms. Smith here?
100 is fine. I'd rather be batting
If
1,000, but that's
Jessica
all right.
Brown,
I'll
yes,
take
Jessica-
100.
That would be Jessica Smith, but I'm not completely sure. When I put her in the breakout room with Mr. Bader, I had Mr. Bader asking for assistance. Nothing I can do.
No,
with
she's
the
here.
breakout room.
She is here.
Oh,
let's deal with that.
I hate to see David Spades in trouble
me,
down
Your
here at
Honor.
the bottom.
Yeah, who's that?
This is Roger Turkowski with Coolidge Park Apartments. I believe I was supposed to be put in the breakout room with Louise Bradley.
Oh,
There you go.
Luis.
I guess you're gonna go now.
If he does it.
He's off the screen, so I think he went.
Maybe James is the court
All right, I'm gonna
artist.
call National Check Bureau versus Jessica Smith. This is case number 05-1515 GC.
Good afternoon, Your Honor. David Bader, representing National Check Bureau.
Ms. Brown is muted. She
Bye,
needs to
Katie.
unmute, please.
Jessica Smith Brown, defendant. Here, Your Honor.
Okay, so you were supposed to go to legal services, or you have legal services representing you?
I did go to legal services. I received a notice 2 weeks ago that they were able to do the case. But during the time that she was in review, I had contacted 2 other attorneys and gave them copy of the file that Mr. Bader had given me.
Jessica Brown went to the Bishop School of Broadcasting.
Per all of their opinions so far, it was the original files, I guess, have been destroyed. And there was some information that they were having a hard time trying to figure out, I guess, how we could even defend. They,
Loud, good to
you know,
see
that
you.
it would almost be impossible to try to determine, prove the original amount of the debt, because the debt was in question was an original $1,000 credit card that had a $1,000 credit card issued by Providian Bank back in 1999.
Oh my! 1999.
I spoke with Adam Alexander. He works in the firm in Southfield, a collection defense specialist, as well as Marshall Schultz, also in the Southfield area,
Hey, Liam.
specializing in collection defense. And everyone's just kind of lost right now. And I don't
And
know.
what now?
They're all feeling at loss because the original files have been destroyed. I had came down to the courthouse to pick them up.
Isn't that
The
a very
clerk
old
said that they had
case?
been destroyed. She did a printout for me and stamped it and said that that was all that they had. But and I
you
guess
can't
it was
collect
supposed to
that.
been a register of actions or something like that is what the attorneys were looking for. So I gave them what the court clerk had printed out, and
Yeah,
they saying that it's gonna be almost impossible to try to determine and prove without the original, documents. And it leaves me worried because it's like no defense for me, pretty much. No one knows how to help because those documents are missing. And what they did say, from what they
Well, let
did
the judge tell
see,
you what to do.
there was no record of me ever being served according to the documents that Mr. Bader provided me, and I'm assuming you, and along with the
Mr. Bader, Mr.
paperwork from the clerk's office.
Bader.
I guess in 2015 is when this new writ or judgment was put into place,
If it,
and I was never served because it's showing an address that I didn't even live at since June of 2012. I didn't
know
live
that.
at that address. And so don't know. And I have really been trying. So that's where all
Can't
three
you just give them
attorneys
like $10
appear
a
to
month
be,
and call it a day?
trying to figure out what kind of, fight could even be put up on my behalf because of the original documents being destroyed.
Okay, let me just make one thing clear.
We'll have to do that sometime.
In terms of the court records, I can't say this 100%, but I'm gonna guess. We were only required to hold on to files. I think it was, what was it, 5 years originally? 6 years, 6 years it was.
No, on general civil, it used to be 10, I know, and then they shortened it to 6.
Yeah, it got shortened to 6 years. So destroying files after 6 years was a regular part of what this court was doing.
This was under 68th district.
Yeah.
Court. Back.
Yeah, this is when it was 68th District Court now. So, you know, it's not like it got lost in a fire or something like that. That was how long they were told that they had to, that was the minimum amount of time they were told that they had to keep it. And they don't want to pay to have to store it off-site somewhere, so, you know, they were doing that, so.
Can I see that register of action for a moment? This is the 2005 file. It actually may have been destroyed in the flood in 10.
Well, yeah, we had a flood in 2010 too, so that it could have gotten lost then too, but
I think
bottom line is,
that's what you said, it was a flood or something.
yeah, but here's the thing, look, that's kind of the whole,
So what you're saying, JG, is just ignore them.
that's
and
kind
they
of
can't
part
do
of the
anything.
whole problem. In that, I think they've been trying to take money from you for all this time. Haven't they tried to garnish your taxes and your wages and stuff? Is that right, Mr. Bader?
Yes, Judge, the first garnishment was back in January 10 of 2006. And we did it all through mostly through 2006. And then I got a cashier's check on, let me see who it's from, in 20 and then 21.
There you go.
Yeah.
Solid advice from JG.
And you
So
told
how
us
much have
not
you
to do anything more. We have collected thus far $10,427.40.
$10,000.
The beginning, but
How much was the original judgment? 9,000.
That's correct, Judge.
I don't,
Well,
I mean, I don't.
So wait a minute, Mr. Bader, all good things have to come to an end. Have you heard that expression before?
I have, Judge, but it was accruing interest of 11.99% per the court.
Good gracious. She'd never get that paid off.
Like, I don't know. Like I said, the beginning part, yes, but everything in between from that 2006 when I was working and they did the garnishment, I was aware of that. But anything after that, Your Honor, before the court, I was not. And like I said,
So the question comes up, why wouldn't you have challenged it back then?
back then, I don't even remember it being $9,000. I can honestly tell you, I remember getting like I guess a garnishment letter. I remember getting a garnishment letter stating that my wages was going to be garnished for a debt. And then it did it. And it was coming out of my paycheck directly. And then I no longer worked there. And then there was like,
But ma'am, let me describe it this way. Okay. Let's say somebody has had their barbecue grill in the backyard and they've cooked their meal.
And somebody
the
gave
coals are
somebody a
still hot.
slushy with alcohol in it.
There might even be flames coming from the coals. But the coals don't go out. but the person knows the coals are hot and maybe burning a little bit. Well, we're at the point almost where the house is caught on fire, the roof is collapsed, and the first story is burned, the second story is burned. So we're now trying to put out the fire when we knew that, those hot coals could have been extinguished.
Your Honor, if I may, I mean, it may not seem a certain way to you, but so as I
That
was
would suck.
saying, that
Well, that would suck
activity
to have to do
ceased
that.
after 7 years or whatnot. I assumed, because things fall off your credit report, and nothing has been on my credit report from them all of this time. Like I said,
I like what she's saying.
got sick in 2010. I have not worked
that's rough.
since 2010. I had a 2-day heart attack, almost died, and trying to still raise my family. There was no contact between Mr. Bader or anyone else in requirement to no debt. As I told you when we first started,
Taking it back,
I
Jules.
was not aware until my mortgage payment and my other bills were declined at the credit union when I filed the objection.
But that's the part of the problem.
Did not file.
That assumption was false. The assumption that it had disappeared because it fell off your credit report or wasn't on there was a faulty assumption.
But I didn't have any.
Congratulations
contact
on being
with
debt free. That's awesome.
any creditor. Mr. Bader had just said to you that there had been no activity, no anything between him, his office or his client and myself. So
Why would that make a difference?
Because I wouldn't know about it. How would I know about it?
This
If I never received.
Well, I guess what you would have to know is that the judgment, it was good for 10 years. You'd have to know that. And I guess you'd have to know that it could be renewed for another 10. Because it's a 2005 case. Those first two numbers are the year, that the case was filed.
You as well, D. I know everybody's celebrating today.
So, if they collected money between 2005 and
He yells a lot,
2015,
PK.
By garnishing your pay or your bank account or something, you'd be on notice by them taking this money from you.
I mean, in 2005, Your Honor, could you ask Mr. Bader to please repeat to you when he received any funds by any means from you? And there is a clear gap between 2006 and 2020. That's 14 years. It was.
Well, can you answer that, Mr. Bader?
I'm sorry. Say, what's the question again? I was pulling up something else on this.
I was buying pop
again
figures.
The date in which you collected.
Funko Pops were on sale.
Sure. I received a check on January 10, 2006, January 24, 2006, January 7, 2006, January 22, 2006, March 7, 2006, 5/2, 2006, 5/16, 2006, 5/31, 2006, 6/13, 2006, 6/27, 2006, 9/19, 2006, 10/3, 2006.
She made tons of payments.
I don't think that was a credit. It looks like a 3/23/2020, November 29, 2021, or 12/01. And the cashier's check was on 3/25/2000.
He was buying a belt buckle.
So.
What was the last one?
With the.
Wait, what was the last one?
I would not, and I.
Hush!
Did not know.
Well, wait. What was the last one, Mr. Bader?
The last check we received was December 1, 2021.
There's more.
I mean, Judge, if it would please the court, I'm happy to let her make minimal payments.
Hey, Mr. Bader, just look. I'm going to say this to both of you, okay? Because both of you are in your own little worlds. And in my world, you just two little boxes on my old TV screen. Okay? When I say to you, Mr. Bader, all good things have got to come to an end, I'm saying really that you've gotten more than the judgment. So you got the judgment plus some interest, which is probably a good day. You've had a good day. It's been a very good run.
You milked it for as long as you can.
And
He's about-
I would
if
say
I
to
may-
you, wait, let me finish. And I'd say to you, Ms. Smith, they're taking all this money out of your paycheck for all this time frame. It's just not viable for me to hear you say, well, I didn't know what was going on. I mean, you got to check on this. You got to follow through. They're not, they don't have, they listen, when they're going to come after your bank account, they don't tell you. They don't have to tell you. They tell the bank so that you won't go pull all your money out of the bank. When they want to garnish your paycheck, well, you know how that process works. If they want to seize property, they're not going to say, we're going to give you a big warning to let you know we're going to come get your car, come seize your Subaru. They're going to, get the judge to sign it. And they go in there, with the sheriff when you're not expecting it, and they come with a tow truck to try to seize your Subaru. So I'm saying,
Your Honor,
yeah.
again.
I want to know one question. Is any of this Social Security money that they got? Are you old enough to collect Social Security?
I am disabled. I've been disabled and since 2010. I almost died. I had a heart attack the last 2 days. I have stents in my heart.
A heart attack that lasted 2 days.
So were you receiving disability money?
Yes, I do.
When did you start?
I was granted before court in March of 2013. But I had not.
Have they gotten money from you since then?
Only in 2021 is when I found out. When I filed the objection, because.
Okay, and is that the $77,720?
Yes.
And was that from your, so let me ask you this.
The original debt from when he was taking it out in 2006. I was working.
Oh, hang on a second. That's from Financial Plus Credit Union?
Yes.
And did they get $633 from you February 21st of 2020?
Not that I know of, no.
Well, we're showing that they got $633.19.
Well,
I
yes.
must have missed that one.
Did you take $633.19, Mr. Bader, on February 21st of 2020?
Disclosure date, Judge?
Well, somewhere around February of
Judge,
2020.
Yes, I got a check for $633.19 on March 25th of 2020. In regards to this being Social Security money, I've asked for her bank statement several.
Go ahead. Because I haven't asked that question yet.
Yes, I,
Just getting spicy in here.
All right, so
You
let
want me to
me ask you
make
this.
my argument?
Are you,
Okay.
I'm getting close to that question, so I guess you're reading my mind, Mr. Bader. Miss Smith, what I want to know is this. Are you required to have direct deposit from your disability money? You get disability from the federal government?
I do.
Are you required to have direct deposit on that?
I don't know if it's totally required. I know they said that they didn't do paper checks, and when it first started, it was
Then I would
always
say
with
yes.
direct deposit. That's how they.
Is it into that same account? The Financial Plus?
No, it goes to the Direct Express card,
That's a good
and
one.
then I have to take it off my card and put it into the account because my mortgage company doesn't allow you to pay with a debit card. It has to physically come from a bank. So I take the money off of the card, and then I deposit it into the account.
Well, how long has that been going on with the card going into the bank?
With the card going to the bank.
How long have you been doing this where you take this money off of, because my understanding was
Get
they
mad.
send those disability, that disability direct deposited to the bank. And this stuff where people put stuff on cards is relatively recent.
No,
So I'm trying to understand.
Security puts it on the card, not me. It's Social Security's private card. It's called Direct Express. And that's where all the disability monies go to. That's just been that way since I was awarded disability back in March of 2013. They automatically did it that way. But my
So
mortgage,
just so I'm clear, so I'm clear, you've taken
I'd never heard of
money
direct
from this card,
express.
deposited into this credit union account.
right, because our mortgage company does not allow you to pay mortgage payment. Rocket Mortgage does not allow
Rocket
you
Mortgage.
physically
Shout out to
pay
Rocket Mortgage.
your mortgage by card, even if I use the debit card that's associated with my bank, I cannot. It has to have a physical routing number and account number. So therefore, I have to take money off of the Social Security.
He's in
Direct
Detroit,
Express card
so maybe.
and physically deposit it into the account when it's time to pay my mortgage.
Is this disability your sole source of income?
I will even be willing to.
No, I'm asking you, is this disability money your sole source of income?
Yes. Except
So all the money
about to say
that's
except,
in
Judge.
this finance, what?
She was about to say
My next-
except.
my husband.
Except your husband, what do you mean?
He helps, financially support our household, but that's my money. Yeah, that's the only income I have.
Well, does he put money into that Financial Plus account?
Not physically. He may give me money with his portion, and then we put it in to pay bills out. He has an account of his own, and I have an account of my own.
Okay, Mr. Bader. So
he trying to
Yes,
grab
so
some of her
I'm
crumbs.
If I may,
Wait, I got a question.
yes,
I got one
for
more
me or her.
question. One more question. So you're telling me that part of the money that goes into this financial credit union account has been from disability indirectly?
Indirectly?
Yes.
Yes. But I don't.
Okay.
Oh, don't
Now,
say nothing
at
else.
this
Just say
point,
yes.
if I
Just say
may,
yes. Just say yes.
He won't even dispute it. Fine, he has it. All I want is this to be done.
Oh, we're changing over there right now. She's back. All right, we're changing.
Okay, Mr. Bader, I'll give you a chance to respond.
Taking very seriously.
She's back.
So
Two kids.
if
that I
that's,
take
if
care of.
that's true, why did the 16th even happen?
She's got an excuse.
I'm sorry, I can't hear you.
If it's true, you're taking all of this seriously, why on the 16th did this incident happen?
I wish I had a good excuse for it. I just don't. I don't want to excuse any of that behavior. I don't want to make any excuses for it. Just that it is not going to happen again.
You sure ain't, because you're going to jail.
I can't make any sort of excuse.
She finally admitted she
I can
just
only
drank.
just beg for some mercy.
Don't give her any. Lay it on her. She tried to tell you her son gave her an alcoholic beverage. Shame. 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 Don't give her no mercy. Don't give her none. Don't give her none. Lay it on her, Judge. Go tough on her.
Excuse me?
Tough love time.
You know, the problem is you had a chance.
Oh, she was taking pills too? Ooh.
Just so that we understand what happened here. You correct me if any of it's wrong.
Sure.
So on the 16th, into the evening, you blow a .08. You're then supposed to retest every 15 minutes, and you didn't retest. Then even after that, I mean, at that point, quite frankly, Ms. Kresnick, this is the part that bothers me. You know you're caught. And then they ask you to come in for an ETG, and you don't show up. So I'm having a tough time believing that you're committed to anything.
I understand that. I understand how the optics look on it. I really do. I really do. I really do.
Okay, yeah, we get it. You really do. Give it to her hard, Judge.
I have never been in trouble before. I don't do these things.
Oh, yes, you're so innocent. You're such a sweet girl.
I can't see anybody.
You won't be seeing anyone here soon. Oh,
What do you
disconnected.
mean you can't see anybody?
Oh, now I can see you. Now I can see you. The screen went black.
She goes in and out of crying very easily, by the way. No, she blew the whole 9 yards. She claimed earlier that her son at a barbecue had gave her a slushie that had alcohol in it, and she didn't know it, and she had drank 2 of them. And he told her to come back because he didn't believe that BS
Tell you
story.
something, ma'am. And I'm just going to try to make this as clear as I can. Even in everything you're saying, you are minimizing your behavior. You are not accepting any of this stuff that you've done on this. You had numerous opportunities, even before this gets to me, to kind of come clean, kind of deal with it, take the test, just accept it. When I first asked you the question about you knowing, I mean, and you went in with your attorney, presumably when you came out, you really kind of lied to me then that, yeah, okay, I drank this, but I didn't know. And so every chance you get, you just either minimize your behavior or you just say, well, I didn't do this. Now, here's the thing that I also know. You're also telling me, well, I don't do this, I don't get in trouble, this is my... The cold-hearted reality is, this is just the first time you've been caught.
Hallelujah, Judge.
You didn't just all of a sudden do something wrong and then this just happened. And so ultimately, you got to take all this seriously or not. I mean, you got your choice of what to do.
I understand.
But you also can't minimize it. You can't just say, I'm not going to do this. You didn't, think about this for a moment. You tested pot, you drank when you weren't supposed to drink. You didn't make it 10 days from the time of the arraignment, and I put you on that test. You didn't make it 10 days. So don't talk to me about any type of medication that you got back in November, because obviously you're not using it properly because you didn't make it 10 days. Then at the 10th day, when you blow, you then decide, well, I'm still going to try to cover up because I won't then follow the instructions that they gave me that I have to retest a positive blow. And so you didn't do that. So then we also then give you the opportunity, God bless the people at Community Corrections, to then try to even deal with that. So you need to come in for an ETG. And guess what you do? This person that wants to deal with this, you don't show.
Sure.
And so this is just a series of mistakes.
It is. It absolutely is. And I don't want to minimize any of it. And that's why I don't want to give any excuses. I don't want to minimize it. It is super
You
serious.
started
I
with
understand.
excuses. You started with excuses. I listened very closely to what your counsel said and what you said. Oh, my kid gave me the drink. Okay, they went there and got you the drink. And if you're going to tell me you didn't know what you were drinking, I don't believe you. You started the whole scenario that way.
This fake. She faker than that girl in the Johnny Depp case.
At least it's alleged that you were almost a .20. You had an accident. And so if I just accept what you're saying, that at some point, what's going to happen is, you know what? You're going to feel that it's okay just to get into a vehicle. And at some point, you're going to take somebody out.
Mm-hmm. Mm-hmm.
Not happening on my watch. Yes, you are. That's what happens.
No, I understand. I understand that that's what happens.
No, you don't.
And then what would happen is that you'd give some excuse.
Mm-hmm.
No.
Just like today. Yes.
It is my fault.
Yes.
Yeah.
Just like today.
Liar.
Pardon me?
Just
Pardon me?
like today, you would be giving some excuse.
Uh-huh. I saw that side-eyeing thing. Yeah, that's really
don't have
weird.
any excuses.
So on the violation, you're right, you don't.
And Judge, I would just,
I've shot them all down. Go ahead, Mr. Gallagher. What do you want to tell me?
well, I was just going to say, Judge, and I've been practicing for a while, and this court's been on the bench for a very long time. But I think that this is someone who's obviously struggling, and one of those first steps is acknowledging that they do have
She was in
an
a
alcohol
wreck.
addiction issue. And I think some of
Blew
the
a .20.
I guess some of the reactions that we saw from Ms. Kresnick are very common of someone in those beginning stages that, kind of denying or playing off
She
that,
got into
that
an
they don't have
accident.
a
That was her
problem.
first offense.
When in actuality, they do.
Made it 10
And,
days clean.
I think she's coming to that realization just in my conversations with her and in hearing her in court here today. I would just ask the court to take that into consideration.
No.
I'm taking it into consideration.
Okay, Judge.
I mean, she's done better maybe than some.
Right.
in that.
She made it 10
Right.
days.
What I'm gonna do, ma'am, is I'm gonna order this. It's now
Stony Lonesome.
2:30. I'm gonna order that you report to the Washtenaw County Jail by 6 p.m. today. You will serve, instead of the 5 days, I will give you some benefit, and you are to serve 3 days in the Washtenaw County Jail. Upon your release from the Washtenaw County Jail, you will then be reported over to Community Corrections. Your sober link will be switched out, and you will be placed on the Scram tether. We will be monitoring you 24/7.
Understand, sir, I just
Going
started
to
a new
give you
job on
one.
Monday.
She said she started a new job.
Sorry.
I just started a new job on Monday. I lose my job.
6 p.m. today.
Oh my God. Started a new job.
Understood, Judge.
This matter will adjourn over.
Please, I don't have anyone to take care of my kids.
Oh my God.
Please, Josh, please.
Started a new job.
Please.
So, who would have been taking care of your kids
when you're drunk?
Had you killed yourself in the accident?
Below over there on the Twitch.
So adjourns out to 5/18/2022, 9 a.m.
She'll remember
6
this.
p.m. Thank you.
She'll remember this.
Thank you, Judge.
She'll think twice. She drinks and drives again.
It's the one they went in on.
I pulled this one if there's still.
Oh, okay. That's it. Okay. Thank you.
Started a job.
Eugene, yes.
Hey, Hugh. How's it going, buddy?
See if she can make it past the 10 days. Court does call the case. We as the state of Michigan versus Epkeet Singh.
It's such a always a go-to, right?
On behalf of the defendant, Your Honor, I have not had an opportunity to speak with the prosecutor or the officer. I'm not sure if the officer is available.
Hallelujah, sweet tea, coming in
And
and
Your Honor,
dropping
the
$5
officer is not
jello.
available. I have tried to call, email, and text him. He is not here. So at this time, the people are unable to proceed on this formal hearing.
Obviously, I dismiss, Your Honor.
Started a new job, Your
People being
Honor.
unable to proceed, case is dismissed. Thank you.
Thank you. Have a wonderful day, Your Honor.
You do the same.
Wow. Thank you again, Teresa, for the 5 bones. Wow. I
Because case
mean,
people versus Trey Hampton.
she got plenty of time to get her affairs in order, right? I guess her not coming to work for 3 days
case.
because she went to
This
jail
is Mr.
might
Kilowog's
be.
case, Your Honor.
Okay, where's Kilowald? He was on here.
I see him on the screen. He just has his video and his camera off. His video and
Kilowald. So Pete. Bob Kilowald.
Where's Bob at?
Mr. Hampton, I'll pass your matter. Maybe if you got another phone, call your attorney's office, see if you can get roused him. I'm falling asleep at the computer. Court calls case, people versus Samuel. Is it Patel?
It's
Batzel?
Batesville, Your Honor.
Batzel? Okay.
Yes.
My apologies.
Caitlin Kirby on behalf of the people.
Good afternoon, Your Honor. Alexander Russick on behalf of Mr. Batesel.
I can't say too much about that.
Right,
Last
what are we
case.
doing
It was
on this
just-
case?
Thank you, Your Honor.
Oh,
I've
yeah.
been in discussions with Ms. Kirby regarding a resolution of this matter, and I believe that we are relatively close to that resolution. What I'm requesting the court today is an opportunity for a Cobb's evaluation of a potential
I did-
sentence based on.
She'll pound him before she goes to work.
And I
Then
did
Your
Honor-
explain
jail.
that to defense counsel.
then I think that we may need a little bit more time for negotiations, Your Honor.
Walter coming in with some theories.
But I believe that we are very close.
Miss Kirby, I think that is like the third time you told somebody that I don't Cobb's, and for whatever reason, they don't believe you and they just try to ask me. I don't know why they do that. Anyway,
Well,
May
usually,
18th.
usually I write the email. The judge does not do that, but if you feel like that's not true, then you can feel free to ask. So they just
So in case anybody was confused, she got 3 days in jail. And when she comes out, they're putting her on the tether where they can monitor her 24 hours a day. The other one was like a one she had to blow into to like crank her car, and she blew a 0.08 after she'd already been in an accident where she blew a 0.20 and had only been on this new monitor for 10 days. She had just been before the judge 10 days ago, and then turned around and got drunk as a skunk once again. And she would conveniently had just started a new job on Monday. So we don't know how that goes.
don't believe me.
Okay.
Well, in my
May-
defense, Your Honor, the email said did not say that, but it said that there would be no Killebrew agreement, but that I could ask you about an evaluation.
Judge Porter's on.
Okay. Well, you asked.
All right, we're gonna head over there
May 18th, 2022, 9 a.m.
because we're adjourning a lot.
Bond
By the way, in
continues.
case
Thank
anyone
you.
was wondering,
Thank you, Your Honor.
Your Honor.
what had gotten done about the lady who owed the money?
Over where I live.
Nothing. Still
Miss-
going on.
Miss Smith,
Let
Miss
somebody
Smith,
on that.
Miss
He keeps calling
Smith,
her
Miss Smith.
Miss Smith.
Yes, Your Honor, I'm sorry.
Is she Brown Smith or Smith Brown?
Mr. Bader, when did you put a lien on her house?
They got a lien on her house now? I
It
can't
was
watch any more of
filed February 16 of 2018.
Oh, what? Okay.
It's not directly on her house, it's on her property she owns.
It's not directly on the house. It's not leaning against the
Where
house.
she's
it's
living
leaning
or
against the
somewhere
property.
else?
Under the Michigan statute with the lien statute, I believe it covers any property she has in the area.
I'm
She
wanting
have
to
her property
know.
all leany.
Okay, all right. Well, ma'am, ma'am,
Yes. Go on.
have you talked to a bankruptcy attorney?
I just bought a house. We just bought.
That
this-
isn't my question. That wasn't my question.
That wasn't his question.
No, I have not. I didn't know that I needed to. It wouldn't have
If you
been.
got a lien on your house, that might be something you might want to think about.
I'm
I'll
trying-
just say that.
What house is he talking about? I just bought this house and closed at the house of end of May in 21. What is it? I don't know what he's talking about. On a lien on the house is 18. What address?
He
is
said
that?
19. He said 19.
He said 2018. What address is that? Why would I file?
Where is the
Okay, I'm getting out of that because I can't take any more of it. That guy's a real asshole. That Bader guy. I mean, I understand the Leo's money. I get it. At the same time, this dude, it just never ends with him. Never ends. We'll go back here to Judge Simpson for a minute while I get Judge Kim up.
I'll tell him to disconnect the internet.
Or cause case of the people versus Andrew Gasbridge.
Stephen Kirby on behalf of the people.
Good afternoon, Your Honor. Ashley Shley with and on behalf of Andrew Gasparich. I do see him present on the Zoom screen. Your Honor, I actually believe that.
See
we
what
need to
Andrew did, and we'll
pass this
jump
matter.
over
Just very
to-
briefly, I did forward over the police report to Ms. Tang, and she indicated that she was trying to get that to Your Honor, so we wouldn't have to adjourn this one more time for the plea. I do apologize.
I have the police report and have partially reviewed it.
Wonderful. And then it is our intention that Mr. Gasparich will be pleading no contest today to operating while impaired. And the basis for a no contest plea is lack of memory. There was an accident involved in this situation, and
Lack
Mr.
of
Gasparich
memory?
does not recall anything that happened due to the situation.
Amnesia.
Said
It really happens.
understanding of the agreement.
Yes, Your Honor, it's 257.6253A.
Well, he's got
Mr.
the,
Gasparich?
the amnesia.
Yes, sir.
Can you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
Your Honor, I have the
State your name for the record.
Andrew James Gasparich.
All right. Sir, it is this court's understanding that you're going to plead no contest to the charge of operating while visibly impaired. Now, that is a misdemeanor. It is punishable by up to 93 days in jail, up to a $300 fine plus court costs. Court could order any rehabilitative services.
Maybe
or
he's like
community
me, needs
service
a
court deems
haircut real
necessary.
bad.
Court could also order your vehicle immobilized. Could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, I do.
All right. And understanding all of that, you still wish to plead no contest?
Yes, I do.
Do you know what a no contest plea is?
I believe I do.
All right. Well, two things about a no contest plea I have to make sure you understand. It means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, I do.
The other part you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, I do.
All right. Understanding all of that to the charge of operating while impaired, how do you plead?
Probably
no contest.
not.
And you
Could've been
understand that by
Creed.
pleading no contest, you'll not have a trial of any.
Wasn't me.
Correct.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have
Oh,
this court
wow.
compel their attendance.
That's
You're giving up
crazy,
your right
man.
to see, hear, and question all witnesses
48
against you at
hours.
trial. You're also giving up your right to be a witness for yourself or to remain silent and not have that
Pretty
silence
much.
used against you. And you're
Pretty
giving
much
up your right to
Dolphins
be
fan.
presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
I understand.
You understand you're giving up your right to appeal over.
Punch the cop.
Are you on probation?
Not current. No.
Are you on parole?
Nope.
Did I say something bad about
Has
the
anybody
Netherlands?
promised you anything
No.
other than what's been stated here today to get you to plead to this charge?
Nothing.
Anybody threaten you or coerce you?
It worked on.
What?
Anybody threaten or coerce you?
No, sir.
You're
Marvin.
doing this voluntarily
Yes,
and of your own free will.
correct.
Court has been handed and reviewed Pittsfield Township Department, Pittsfield Public Safety Department report for their case number 19-14158. Any objection to the court reviewing that report?
No, Your Honor.
No objection.
Probably not.
Court upon a review of that report does find that there's a sufficient factual
Said
basis in
yesterday
which the court
that
could determine the
some
defendant's
Frank
guilt of
said
this
something
offense.
weird. He
Counsel,
reacted
have I
and
complied
said,
with the court rule?
The
He is
people
from
are
the
satisfied.
Netherlands. What do
Defense
you
is
expect?
satisfied.
Yeah, because our friend Fred Franklin is from there.
Court will accept the defendant's
Yeah,
plea of no
Fred
contest
Franklin.
to count two, count one is
That's just me
dismissed.
giving him a
So
hard
you
time.
are referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel.
No, I think
Sentencing in
Fred's
this matter
weird.
will be May 11,
Fred's a weirdo.
2022, 9 a.m.
I don't really
Bond
know
with its conditions
many
will
Dutch
continue.
people.
Thank you.
Oh my gosh.
Thank you, Your Honor.
Y'all in a bunch of seizures.
Court calls the case.
Fred knows what I'm
Pro
talking about.
Services, Inc. We have two cases.
If I offended you, Walter, I would like to apologize to all the Dutch people. Because for heaven's sake, I don't need a nation on my back.
Who was counsel on this?
All right, we're going to
Can you
jump
hear me
out
now?
of this one.
All right, and so, well, let me see. I don't know if I can, you have such a soft voice, Ms. Usually. I'm not sure if I need to turn this up. There we go.
Judge Porter didn't stay long.
All right.
Judge
All right,
Terry
you're
already in
18
here.
Years old, you achieved level 1 outstanding, but you've been here for the last 10 days. You are here on a directive to apprehend. Let's see where to start here. Let's see, your release on EM after you were brought in as a runaway. You were found
No.
in Bedford.
Walter's fine. It's all good.
Doing a bunch of stuff, but we don't need to go back through that. You released on EM on February
That's what I was thinking
28th
too,
for
Mark.
numerous EM violations. Judge Porter ordered a judicial review to address your violations, and you were made aware that you had to be present for that. You continued to have EM violations despite knowing you would see Judge Porter, so a DTA was issued prior to the actual judicial review date. And then on March 2nd, you received an out of custody referral for graffiti with a pecuniary loss of $2,500 to $30,000. Okay, then on March 9th, you received an out of custody referral for an unlawful carrying of a weapon in prohibited
Oh,
places.
bud, you're
USPD
fine. It's
responded to information that you
It's
might
all
have sold
right.
a gun at Trinity High School in relation to the theft of firearm offense. On the 14th of February, USPD reviewed a video of the Trinity High School cafeteria.
You're good,
You were
Walter.
seen
Don't
entering the
worry.
bathroom twice with someone beside you.
I'm sending
You
a
were rumored
letter
to have
to
waved
the
and pointed the
Dutch
gun in the
consulate
bathroom.
as we
Students
speak.
that entered the bathroom were identified, spoke with the PD, and denied seeing you with the gun. The alleged purchaser of the firearm denied buying it. The student reported to have seen you with the firearm on Snapchat. Refused to provide information on what was seen on Snapchat, and who was seen on Snapchat. So they have no evidence to support that, but they did write a report. So when you came in on the 8th, I'm not quite sure how they found you because this is not, I don't have that information here. You were positive for marijuana. Hadn't taken your medication in 2 to 3 weeks. You refused to engage in MHMR services that your father's attempted to arrange for you.
Do they have a thing over there called a Dutch baby? Because I've heard about
Right,
that.
so you have
It's
pending
like
the theft of
a thing
firearm
you
and
eat.
unlawful carrying of a weapon in prohibited places. Does he have a court date yet, Stephanie? Do you know? No, you just jumped back on, sorry.
Smoking a pancake.
In any event,
Not yet, but they probably
due to the
will.
nature of your offenses and the fact that you cannot be trusted even on an electronic monitor, and on top of that, you've only achieved level 1 outstanding as of 2 days ago, I'm going to go ahead and keep you detained, Aiden, until I'm comfortable releasing you, knowing that you will follow the rules, remain on EM, not abscond, and not pick up any more
I'm weird,
offenses.
Walter. You'll learn that after you've been here a while. I'm weird.
What's that? No, not yet.
I too love fishing.
Rolando. Hi, Rolando. I'm Judge Terry. This is your 10-day detention
beard,
hearing.
son.
You have a right to have this hearing every 10 business days once you've been detained. Purpose is
Kentucky.
to determine whether I can release you to a parent or a guardian, or if I should keep you detained. You have a right to remain silent and a right to an attorney. Your attorney is Larry Bieber, and he's here on Zoom with us.
Good
I do-
afternoon, Judge.
Good afternoon.
She
And I
wants
do
the
see that there's a
flusher.
parent here. Are you dad?
Judge, he's Spanish speaking. That's his brother, an older brother.
Okay.
Oh,
All right, level 1 outstanding as of 4 days ago, but you've been here since January. You are pending evading arrest, detention with a vehicle, reckless driving, unauthorized use of a vehicle, theft of firearm, and burglary of vehicles. Ranging from July of last year until January of this year.
I wouldn't say all that.
You tested positive for marijuana and benzodiazepines in
Oh,
January.
me apologize. Again, I've offended a whole nation. Damn it. The Dutch oven. I am aware of that as well.
Your Honor, if I may.
Yes, sir.
Terminator knows
Thank
what I'm
you.
talking about.
So I believe that Rolando has been at 1 outstanding for the vast majority of his time while in detention. And we finally were able to find somebody that we think would be a suitable adult who can receive him, his brother. So we're hoping that the court will allow him to go home.
Well, the information I have said that he's been living with his cousin for 2 years. So where does brother come from?
But the brother lives in Fort Worth also, just that the court had concerns about the cousin since it was the cousin who allowed him to drive the car without a driver's license.
Mhm. Well, why was he with the cousin and not his brother before? Do we know?
I
He's about to
don't
put
know
it in
why.
end
I
zone.
just believe that he had a relationship with the cousin and the aunt, and the father is making himself unavailable to the court just out of fear of his immigration status.
Oh, wow. The dad's illegal. He doesn't want to get thrown out. Nice beaver. Ooh, Walter coming in hot.
He last completed 8th grade and he is 16 years old. He hasn't been in school for the last year.
Might be time to put him back in school.
Okay. His brother lives in Fort Worth.
Yes, Your Honor.
Yes, Judge Daniel, the brother's actually in the parent courtroom.
Right, yeah, I see that, yeah. Thank you. Is his brother employed?
His brother works in roofing, Your Honor.
Yes, Judge, he does.
And so who else is in the home that can help supervise Rolando?
His wife does not work, Your Honor. She stays at home. And so she would be able to make sure that Rolando does what he needs to do. And I'm sorry, if the court would prefer to hear the answer directly from the brother, then I'll
I mean,
stop.
if you know, that's fine. Mr. Beaver, you're an officer of the court. I trust what you have to say. So,
Okay.
if you have the information. So,
Y'all heard that, right?
are they able to re-enroll him in school or some sort of credit recovery or GED or something? Because he's about to be 17, so.
When I talked to the brother at the last detention hearing, he said yes, he would be willing to enroll him in school. He would just need our assistance just to let him know where to enroll him.
Okay, are they able to, do they have the required documents to be able to do that?
That I don't have the answer to.
Okay.
That's a
Well,
possibility,
I just want this
JG.
information for next time. So I'm not inclined to release you today, Rolando, because you have been level 1 outstanding for just 5 days, and you've been here since January, and you know the drill, that you're refusing to remain level 1 outstanding for a significant period of time. And due to that and the nature of your offense history, I'm going to go ahead and keep you here, and that will give your brother time, because it appears to me that he's the only one that we can consider releasing you to. So that will give him time to figure out how to set everything up for you at home. But for today, I'm going to detain you. Thank you.
Thank you, Your Honor.
You're welcome.
Karenoth coming in. A little bit of that under the table money. I likes that. Well, guys, you know what? I want to call it a day. We got Wild Woman Wednesday coming up. We got a chase. That's at 4:05. Not too long from now. I'm going to go ahead and jump out of here so I can stretch my legs. That kind of thing. You know what I'm talking about. Yes, Walter, you're fine. You're fine. You're among friends. You call me out on anything you want anytime. It's all good. Dumb question. What does OG stand for? The original gangsta. The OG. So when you hear say the OG show, that means it was the original thing that we ever did together when we were just lowly radio people before we ascended to greatness here on the intranet. So if you ever hear say the OG show, we're talking about it's the closest thing we do that is similar to what our old radio show was. Hence the name CB Radio Show. Hence the name Credence of Bishop. And I'm not Bishop. So if people are ever confused why Bishop's name is on here, it's like a homage to something that once was. So make sure everybody is back here. You guys all got it. You all know what's up. Make sure you're all back here for we got a Chase Wild Woman Wednesday on tap. A lot of good stuff. All with women's. one that you really need to see. It's a doozy. All right, guys. Appreciate everybody. Nothing but love up in his peace. And until next time. What was that thing I used to say? Oh, yeah. Please and thank you. Remember. Right? Right.
Too sweet.
Dun, 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 dun. Dun, 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 dun.
$2 cash.
These biscuits.